to the needs of the weak, for which you are also highly recognized both in academia but also outside of academia, including the prestigious decoration that you received from our King Willem-Alexander last year. Our Faculty of Law is grateful that you are willing to take up this chair on socio-economic human rights, a topic that is high on the agenda, both academically but also, again, in practice. And we're happy that you're willing to work together with colleagues from Maastricht on exactly this topic, and thereby give a new impetus to this field in our faculty and university. And I'm equally grateful to the University of Groningen that they're willing to allowing us to borrow you for 1 day a week. Although one day, this week, we see no less than 4 events in which you play a very important role. The MOVE seminar, I already mentioned earlier today. Your lecture here, in which you also play an important role, indeed. The annual EISS conference tomorrow. And very importantly, the PhD forum on Friday. All happening at 4 different locations. So anyone who participates in all 4 will get to know the city of Maastricht really well. You keep us busy, so thank you so much. Now there's perhaps still one question that needs to be answered, which is why would a professor from Groningen, waar niks boven gaat, if I'm well informed, move to the south of the Netherlands? Is it because there is a lot south of Groningen? Although you live in Drenthe, that helps already. I think that your contacts with Maastricht have been there for a very long time, with Professor Saskia Klosse, with Professor Anne-Pieter van der Meij, and with many other colleagues here in Maastricht, with whom you have indeed closely worked together over the years. And this appointment will surely strengthen these academic ties. And of course you are, I didn't want to mention that, but I still do, you are a jongske uit Sittard. Although I'm not sure that for someone from Sittard, coming to Maastricht feels like going back to your roots. We are in any event very happy to have you here and very happy with your appointment on this chair. Professor Vonk, I now invite you to come forward and give your inaugural lecture entitled Welfare State Dystopia as a Challenge for the Right to Social Security.
So, distinguished Rector Magnificus, Dean of the Faculty, thank you very much, Jan, for your kind introduction. Dear colleagues and students and sweet friends and family, how good of you all to have come. I highly appreciate that. Yes, and this is my 3rd inaugural lecture. This is my 3rd inaugural lecture, even though in my 2nd lecture in Groningen I promised not to have another one. But here we are. It was actually last year that one of my younger international colleagues inquired whether I always give the same lecture. That was a bit cheeky, of course. But yes, this lecture is again about the right to social security. After a long journey, I shall touch upon this subject once more. There are novel questions and hopefully new answers. My focus is on welfare state dystopia. I reserve the term for the alienation and oppression of benefit recipients by the social security system. There are things in social security that go well, there are things that go wrong. In the slipstream of the many social security scandals that have occurred, a collective soul search is going on. How is it possible that the welfare state has lost its human dimension? And how can it be restored? Solutions offered come under various banners: empathy, responsiveness, human professional ethics, suggested by colleague Iris van Domselaar this year in Amsterdam. These are all concepts that are valuable in their own right. But I will take a different turn by discussing the right to social security. It is not actually that another legal interpretation of this right or such a right immediately would save the world. But I feel that a law has to keep its house in order not to become an accomplice in things that go wrong. It should offer a remedy to those who are oppressed by the system. So when a lack of respect for claimants is seen as a human rights problem, usually it is the civil and political rights that are called upon. Less often so social rights, and least of all the right to social security itself. To me, that is an anomaly. Legal doctrine cannot just adopt the stance that we are only there to ensure that a system of social benefit is introduced regardless of the consequences for the citizens. Yet, to a certain extent, that is the prevailing interpretation of the right to social security as it stands today. Meanwhile, civil and political rights are equally unable to fully address the ills of welfare state dystopia. And that points to a gap, a human rights void. And if it is true that such a void exists, then it is not just that bureaucrats, parliamentarians and courts are not doing their jobs properly. It is also that these officials simply do not have the normative tools to provide a proper remedy. And that is a proposition I would like to investigate a little further with you. In the first layer, I will delve into this notion of welfare state dystopia. In doing so, I will also pay some attention to the rise of a right-wing populism. A bit of a tricky subject, isn't it? Right-wing populism, which is a development which, in my eyes, is a further cause for concern. In the second part, I will discuss the lethargic response of the right to social security to the dystopian threat, also in relation to the corpus of civil and political rights. And in the final part, I will formulate 3 qualitative standards to enrich the interpretation of the right to social security. So in this way, I shall make a journey from darkness into the light that should hopefully lay a solid foundation for the drinks at the reception. So, let me see. Yes, welfare state dystopia. What exactly is that? Some of you probably know that I always like to start my reflections on this subject by blaming Franz Kafka. In his book, the Proces, the book is a symbol of how a bureaucratic legal system can crush the innocent citizen with a strange, absurd logic. Someone must have been telling lies about Joseph K., the story unfolds. He knew he had done nothing wrong, but one morning he was arrested. That, of course, is the first sentence of the Proces. And as the story unfolds further, it becomes clear that the legal system does not really come to the rescue of poor Joseph K., rather the opposite. But you have to know that Kafka, of course, studied law in Prague. In 1908, he began working for the brand new Institute for Industrial Accidents in the Kingdom of Bohemia. So that made him one of the very first social security lawyers. He had clearly found a very inspiring working environment, but that did not bode well for the future of social security law. Delving into welfare state dystopia subsequently became a passion of sociologists rather than lawyers. It was Habermas who warned us against excessive legal regulation and surveillance in the welfare state. In his view, these lead to a colonization of the life world. Normal human relationships become polluted by impersonal bureaucratic systems. Frankly, every time I use the term of welfare state dystopia, I worry that I am exaggerating a little bit. But you only have to look at the many social security scandals to change your mind. Because just as we are getting used to the testimonies of the victims of the toeslagen affair, this country, we became aware of what was going on in Australia with robo-debt. This is similar, but even a more frightening calamity with 500,000 Social Security recipients being pursued for Social Security debts that turned out never to have existed in the first place. Then we heard about the NAV scandal in Norway. It's a little bit less well known. It has its characteristic of far-reaching miscarriages of justice, resulting in extreme prison sentences for European migrants on invalidity benefit who had not declared their absence from Norway, temporary absence. This was then followed by Mr. Bates versus the Post Office. It was a program on television, and English television, which showed the odyssey of the sub-postmaster in the British Post Office scandal. Mr. Bates was accused of fraud after the Horizon software wrongly calculated the shortfall in his books. And although he was not the only one to be falsely accused in that way, it took this drama series to open the eyes of the British political establishment to what was really going on and to come clean. In the meantime, as we know, in these countries, parliamentary inquiries have started, political heads have been severed, and compensation schemes rolled out, paying billions to the victims. Frankly, it would be a bit naive to treat these scandals as isolated incidents. They rather point at structural deficiencies. The fact of the matter is that contemporary welfare states yield enormous powers, operating with an overload of conditions, excessive surveillance, unforgiving recovery practices, and harsh sanctions. And this is all supported by an omnipotent yet uncontrolled ICT industrial complex. Computer says yes, computer says no. So welfare state dystopia is not an exaggeration, and no longer just a matter of alienation, as Habermas saw it. It has become a matter of oppression. The central feature is that people are treated as invisible numbers and deprived of their dignity. Indeed, when you listen to the testimonies, the latter aspect is often emphasized by victims. So I quote, "In the end, it is not the money I had to pay back that bothers me. It is the shame of being branded a fraudster, of not being able to look in your neighbor's eye, to be excluded from society, ostracized." The story of dystopia doesn't end here. The harsh treatment offered by the welfare state is not equally bestowed on everybody. Dystopia favors the poor, many of whom are ethnic minorities, immigrants. This is typically the lesson learned in the Dutch toeslagen affair. As we know, the victims, who had kept their plight to themselves, began to rally support for their case, only to find out that not only they, but also the other participants in the public lobby were representatives of minority groups. Most of them, by the way, as single mothers. As it turned out, this was not coincidental. It was a result of a sequence of biases operating in the system. Now, there is one last thing I will bring up in this, let's say, starting episode of darkness. And this is the rise of right-wing populism in the political arena here in this country, in the rest of Europe, and clearly on the other side of the Atlantic. This has a bearing on the welfare state. Populism is based on the idea of a unified will of one mythical people represented by a strong leader who declares all his political opponents enemies of the people. The enemies are presented as members of an elitist system, serving only their own interests. Populist governance feeds on clientelism. It forges a bond between the state and the people using social benefits as a tool. But it is a game of us against them. The hard-working patriots are placed on a shield as examples of the real people, as Nigel Farage of the UK Independence Party put it. And all the others are portrayed as parasites feasting on the life juices of these real people. It's an old political trick, of course, trick of going low, but many fall for it. Just take a little time to read some of the hateful messages about the others on populist social media platforms, and then you will know what I'm talking about. So however much populism may like social security for their own gains, it does not adhere to a value-based social state, one that sees the other in the self, as Obama kept reminding us. In that way, it operates as one of the drivers of welfare state dystopia. Barack Obama, mind you, was the only president to write in an academic journal during his presidency. I mean, only US president, and with us we do it all the time, of course. But, and the article, it was a broad article, and it was actually on, what is it called, the Affordable Care Act, Obamacare. So Obama is a Social Security lawyer too. So there's a little hope for Social Security law after all. So after this first reconnaissance, let us now move to the next question of how to keep that monster of dystopia under control. My mind automatically turns to the right to Social Security. In most of the countries, it enjoys a constitutionally protected status as a social right. So what is this right about? Time for some legal thinking, or for some of you, apologies for some legal thinking. For many, the rationale of this right goes back to the notion of no food, no freedom. In other words, true freedom cannot exist in a society where people are burdened by poverty and deprivation. This was also the understanding of Franklin Roosevelt's freedom from want, ultimately a liberal notion. The legal conception of the right to Social Security follows that understanding. It emphasizes the obligation of states to develop an infrastructure to provide social benefits, whatever form it may take. There must be a system available, accessible, and adequate, in the words of the UN human rights institutions. This focus on realizing an infrastructure for Social Security transfers explains the strong reliance of the legislative responsibility of governments. After all, it is in the political arena that decisions have to be taken about the social architecture, with its huge financial implications. But this, as such, does not mean to say that the right to Social Security cannot be invoked before the courts, at least not necessarily. It is true that the justiciability of the right is often seen as problematic. Nonetheless, in many jurisdictions nowadays, judges do find ways to protect the collective levels of protection against interferences by the legislator, offering procedural guarantees against retrenchment or defining a minimum level of protection. It has all been recently laid out in the doctoral research by Eleni de Becker, who I've missed, but she suspects she's here. But even then, the problem remains. Is this approach sufficient to keep welfare state dystopia at bay? I do not think so. That would require a stronger focus on qualitative guarantees for the proper treatment of individuals. And in all frankness, legal doctrine pertaining to the right does not pay much attention to such qualitative guarantees. Not that they are completely absent, they are rather less prevalent in legal doctrine, perhaps relegated to the second league. A lack of qualitative governance can perhaps be explained in historical terms. Social rights have developed in response to 19th century capitalism. They have given rise to an interventionist welfare state that purports to liberate people from the whims of the market, making use of a plethora of social transfer. And legal doctrine reflects this rationale by focusing on the promotion of a social benefit system. But now that the systems are put into place, they run the risk of turning against the very people they set out to protect. It is my conviction that the legal doctrine will have to face that challenge. It must be accompanied by stronger qualitative guarantees that protect individuals from the social bureaucracy. Is the challenge taken up? As I see it, the onus for the protection of human rights against the welfare state dystopia does not currently lie with the right to Social Security. It is placed on the corpus of civil and political rights as we find them, for example, in the European Convention on Human Rights. In a way, this is understandable, since these rights are there to protect citizens from state interference. It is also convenient to let the European Court of Human Rights take the lead, because its decisions are suitably enforceable and legally binding. As a matter of fact, the European Court of Human Rights has responded very well to the need to provide protection against an omnipotent welfare state. It is impressive. The case law has crept into every nook and cranny of the system, from recoveries, sanctions, medical assessments, to the obligation to provide shelter in case of emergency and extreme poverty. Lieneke Slingeberg and Ingrid Leijten, both present here, can tell you about it. Yet, in my view, civil and political rights can never operate as a full substitute for social rights. This is not only because the European Court of Human Rights is still a long way from accepting the level of protection similar to that of social rights. It doesn't even formulate a right to a minimum standard of living, for example. But besides that, the relevant rights are not really capable of thwarting the threats ensuing from welfare state dystopia. For example, the right to privacy is laden with exceptions and pitfalls, giving large powers to governments to process data. Similarly, the right to non-discrimination may require a high burden of proof, which is not easily met when adverse treatment is not directly and singularly linked to suspect criteria such as gender or race. Civil and political rights are ultimately based on the notion of formal equality before the law and are not focused on adverse treatment of groups of disadvantaged social, economic, or cultural backgrounds. Social rights, on the other hand, start from such inequalities and demand that these be compensated. Now the time has come for the right to make work of its own qualitative standards against ill treatment. Moving on to 3 new qualitative standards, represented by these 3 robin eggs, I think it is, or perhaps blackbird, I'm not really quite sure. So let's stop the talking and do the walking and see what kind of qualitative protection can be put in place. I propose 3 concrete standards: compensation, elevation, and participation. Starting with the notion of compensation, as I understand it, it has nothing to do with the circus of paying out damages to victims after the scandals have occurred. This was the theme addressed last year in the inaugural speech of Jacobine van der Brik in Amsterdam. I rather use it to refer to the recognition that people who are disadvantaged, vulnerable, or from minority groups need to be given extra support to enable them to participate normally in society. In other words, it is about inclusion. Compensation for inequalities is a social right imperative. We cannot ignore the divide that exists between those who have sufficient economic, social, and cultural capital and those who lag behind. The poor working in precarious jobs, who struggle from day to day to make ends meet, who face daily discrimination and are relatively much more dependent on the welfare state. Compensation is not just a theoretical notion. It can be applied in practice. Just to give that example, the Dutch highest administrative court interpreted social fiscal legislation in such a way that the tax authorities are always under an obligation to recover the full amount of unduly paid child care allowances. When the harsh consequences of the recovery practices became public knowledge, the court was forced to change its mind and allowed for a proportionality test. This U-turn, was motivated with reference to a study of the Dutch Scientific Council entitled Weten is nog geen doen. Weten is nog geen doen, so that's knowing is not doing. And that report relied on evidence that people's capacities to act rationally may be inhibited due to life events or stress resulting from structural poverty. This insight inspired the court to take due account of the personal circumstances of people when determining the amount of the repayments. This is exactly an example of how that principle of compensation may work. The only pity is that the court failed to represent this new insight as a mandatory consequence of applying social rights. Now it is just an acquired insight into human behavior. But taking into account someone's personal situation should not merely be a court's prerogative. It must be seen as a constitutional imperative following from the right to social security. And that would give the soft notion of responsiveness and empathy a hard constitutional status. Let us move to the second standard of elevation. This means that the conditions imposed on a beneficiary should always be conducive to his or her developments and position. The principle is particularly relevant to remedy the trend towards conditionality in the welfare state. That is a trend that feeds on the neoliberal fixation with educating people to become self-reliant, responsible consumers. If not voluntarily, then by disciplining them with all sorts of behavioral conditions enforced by sanctions. In reality, however, not all people are able to live up to these lofty liberal ambitions. The long-term unemployed, single mothers in precarious employment, people with mental or physical problems, people in debt, dropouts, victims of domestic violence, the homeless, people struggling with addiction. There are those in whose lives the bus has forgotten to stop. For them, it is necessary to check that the conditions imposed are not merely disciplinary, but are genuinely helpful in improving their situation. Elevation can be tested abstractly, but also concretely. An example of the abstract approach is the 2018 sanction case in which the Bundesverfassungsgericht in Germany examined a strict sanction regime in the social assistance system. It contains a meticulous analysis of the state of research on the impact of harsher sanctions on people's behavior. According to this research, there is insufficient evidence that harsher sanctions are effective or beneficial for the chances of the beneficiaries. And for Germany's highest court, this empirical insight was yet another reason to declare the sanction regime unconstitutional. But that is abstract, but it can also be tested in concrete terms. If, for example, it is considered justified to oblige recipients of social assistance to do unskilled work in order to gain work experience, this does not mean to say that such an activity can be imposed on an experienced 60-year-old builder who has become recently unemployed due to unforeseen circumstances. He does not need to gain work experience. He is simply punished for being unemployed. Judges should constitutionally be compelled to take that into account. Finally, thirdly, participation. By this, I mean the stakeholders, the involvement of stakeholders in policy development and implementation. The voice of the citizens should be taken into account, if not directly, then indirectly through forms of representation by trade unions, client councils, or interest groups. The need for participation appears in the case law of social rights institutions. It is also defended in literature. For example, our Amsterdam colleague Anja Eleveld, I'm sure she's here somewhere, I think I look straight in her face, hello Anja. Anja Eleveld and her colleagues some years ago have written extensively about the importance of voice for social assistance recipients who have to perform compulsory work. Long before Anja, and in a much broader context, the legal philosopher Henry Shue wrote about it in his groundbreaking work on basic rights. Shue worked not only from the proposition no food, no freedom, that's the proposition we started with, he also worked from exactly the reverse proposition, no freedom, no food. And it is exactly that reverse proposition that I am inquiring today in this lecture. So I read with particular care what Shue had to say about it. He selects participation as one of the freedoms that serves as a basic right, meaning that it cannot be reduced in the name of any other right. From the point of view of the adagium, nothing about us without us. And I agree with that. In a welfare state, which is capable of unleashing so much power and influence over ordinary lives, citizens' involvements cannot solely rely on parliamentary democracy alone, allowing for a vote every 4 years. Of course, taking into account the client's viewpoints in policy and administration is difficult. There are many ways that lead to Rome, ranging from participatory budgeting, town hall meetings, co-designing, deliberative pollings, citizens' assemblies. Governments and bureaucracies should not shy away from being experimental here. And then viewpoints can also be taken into account individually. For example, when deciding the best way to reintegrate persons into the labor market. On the other side of the spectrum, a collective complaints procedure with an independent authority of experts could be a useful tool to strengthen the participation rights of claimants. Some of you know I've always been a proponent of such a procedure here in the Netherlands, specifically for judging alleged violations of social rights. And perhaps one day we see the light, now that the Dutch Human Rights Agency has made social rights its very priority. As a final note, I would like to add that participatory governance is exactly the opposite of the cult of leadership, Führerprinzip, advocated and practiced by some populist movements. Also, some of the other elements that I touched upon are in opposition to a populist welfare state. Extra protection for minority groups and fight against repression. And I find it reassuring that it is possible in this way to formulate critical markers that flag the difference between a constitutional state and a populist welfare state. A constitutional social state versus a populist welfare state. So, dear friends, it's time to draw my argument to a close. Compensation, elevation, and participation. I have formulated 3 qualitative standards to protect people against welfare state dystopia, to augment the interpretation of the right to social security. These standards need to be taken from the shelf and put in the limelight. I know that taking these standards seriously will place a burden on the 3 branches of state power, and some may see that as a disadvantage. I know some of you see that as a disadvantage. So, what about the doenvermogens of the governments? I know, there you are, Herman. Herman Breuer, Professor colleague Breuer, is a good colleague, but also sharing not really the same room, but our rooms are opposite to each other, so we have a lot of chances to discuss things. So, these standards, if you apply them properly, may burden the administration. But there is, in the end, a relation with the kind of social security systems that we are building in the first place. Universal, unconditional forms of social security require much less supervision of the claim as conditional means-tested schemes do. Ask the Social Insurance Bank. They know about that as a guardian of the Dutch national pension scheme. The bank is well represented here, and I'm sure they are willing to take your questions later at the reception. There may also be those who worry, and I know there are some of you that worry about that, who worry that a new focus on qualitative standards for individual treatment takes away from the collective values, such as solidarity. Indeed, individual claims may conflict with the general interest. But does such a conflict occur when augmenting the right to social security with these qualitative standards for respectful treatment? I rather doubt that. It is, for example, difficult to see how the compensatory principle, taking into account socio-economic differences, run contrary to the principle of solidarity. So the right to social security as reinterpreted in this lecture must be applied by the legislature, by the administration, and the judiciary, both nationally and in the EU by the Court of Justice. We've been discussing this this very morning during the MOVES conference. And in the light of the potential of these standards for judicial review, we may wonder, are these standards freedoms or are they just promotional social principles? I mean, the more easily they are considered to be freedoms, they can more easily be applied by the judges. But I think perhaps there be a bit of both, and that would be a perfect outcome, a resolution of the conflict between the liberal state on the one hand and the social state, like a synthesis, as if the clash between negative and positive freedom, theorized by Isaiah Berlin in his famous lecture on the 2 concepts of liberty, were finally overcome by an internal human rights dialogue, combining a strong welfare state with respect for the individual. Thanks. No. Just give me some time to express my thanks, and then you can all applaud. So it is a privilege, a real privilege, to have found a platform today to take part in this intellectual debate. First of all, I would like to thank Maastricht University for offering me this platform. If there is anything that can breathe life into the stone of an old man whose dancing days are over, just give him a new part-time chair. And how refreshing to suddenly find yourself part of a department of public law with its own identity and characteristics. And not to mention my dear colleagues from the section of social law. Long may it live. Anne Pieter, Mariolina and Jan, I promise you to do my best concentrating on the promotion of social rights in the Netherlands with the emphasis on the right to subsistence security, bestaanszekerheid in the broader sense of the word. Mariolina, of course, incarnated in the person of Jo Sille, who's representing her today. I would also like to thank Instituut GAK for helping, as always, to fund our social rights project that Saskia Klosse and I are leading with the help of Lady de Becker. Together we owe debt and gratitude to Ernst Berlin as chairman of the Scientific Council. We selected him a little bit as a kind of guardian angel for our social rights project of Instituut GAK. Hopefully not too much his will, because he hasn't turned up today, but I'm sure he had good reasons for that. But then, of course, being a guardian angel is also, yeah, it's a very important official affiliation. Huh? So together we put our hope in our two young PhD candidates, Mark and Max. I regularly mix up their names, so I have decided to refer to them as the Marx brothers. May we see much of them. And of course, the other PhD candidates that are currently working in the field. I'm not sure how to put this, but in what order. Well, I think I would say Valerie, here, present, Eddie, Maarten, and many others. A complete new generation is awaiting. Finally, I would like to thank the University of Groningen, the Department of Public Law, especially Wilbert Kolkman and Kars de Graaf, for graciously letting me go for 1 day a week. And how great that some of my dearest Groningen colleagues have taken the trouble of joining me. It's amazing, actually, you made it with the Vissersbrug being closed and all that. But when the Vissersbrug is manned again, we'll take the social rights project to Groningen in an attempt to present a blueprint for a social paragraph in the Dutch constitution prepared by students from this university and from Groningen, with the help of young civil servants and client representatives. I reserve all my other thanks for a next occasion, however much that feels like tempting fate, but I get emotional, so don't do that. Let me just rather thank all of you who are here for your patience, to listen to me in whatever capacity. So I'm now most of all looking forward to enjoy an entirely different kind of social security. That's the certainty of having my 5 o'clock drink, which I'll have together with you. So, ik heb gezegd.
Thank you so much, Professor Vonk, for a wonderful lecture, very much tying in indeed with the combination of fundamental academic research and the needs of those who need this most. So thank you so much. Perhaps I can add, I also liked myself very much the photos on the slides that you showed us, which made me already think of Easter and spring. Indeed, the new dawn for social rights that is very much present this week here in Maastricht. So thank you so much. Many congratulations to you on this appointment. And I also congratulate your wife, Paula, and your children and all family present here today in this room. We are slowly reaching the end of this ceremony. You started with saying that you would lay the foundations for the reception. I think you did with your inaugural lecture. You are not yet done. There are still 2 days of activities ahead. But I want to already thank you all for joining us for this academic ceremony, both here in this aula, but also many thanks to those of you who participated online and watched the ceremony at home. I have one practical remark, which is to everyone who is present here in the aula. There will indeed be a reception that takes place in the refectory right here in this building, where you will be able to congratulate Professor Vonk. And to the participants online, I suggest to propose a toast at home to our new professor, at least here in Maastricht. And with that, I also officially close this academic ceremony.
Fuck's up.